Chapter 14. Arbitration Mechanics. Outside sources are underlined in blue text. Forms available in our Forms package are underlined in red text. Links to each are below this video. What a good choice you've made to have your dispute decided at arbitration. This is your escort into the arbitration arena. Armed with the fruits of this chapter, you'll be able to streamline your arbitration for optimum results in a minimum of time, assuming you have set the stage according to the arbitration chapter. Your arbitration keys to success. Once you've customized your arbitration proceedings, there are two basic keys to arbitration success. We addressed these in the arbitration chapter, but they are so important they need to be reiterated. When you customize your arbitration with the right arbitrator and discovery plan, you will be on your way to a successful result. When we use the term success here, we don't mean only the best legal result. Time and cost savings are just as important. A successful arbitration controls both time and expense. Why? You're there because you don't want a long, drawn-out, expensive, draining fiasco in the House of Horrors. You want a fair chance to have your dispute heard and decided soon by an arbitrator with skill, experience, and wisdom. Key 1. Select the right arbitrator. The first key is to select the right arbitrator. Select someone, preferably an attorney or retired judge, who has extensive experience in the subject matter of your dispute and good performance reviews. After all, this individual will be judging your dispute, and you want someone who has vast experience with its subject matter. Key 2. Control discovery and hearing duration. The second key to your arbitration success is to control discovery and hearing duration. We covered this in the arbitration chapter, but again, it needs to be repeated. Pre-hearing fact-finding, discovery and duration of the hearing should be addressed in your arbitration agreement for optimum benefit and least expense. You'll want to agree to a discovery package that meets the needs of your dispute. In some cases, that may mean only one 4-hour deposition per party. In others, it may allow only production of documents by each party. In still others, it may include written questions to one another and no depositions at all. Key 1. Selecting the right arbitrator. You might want to look twice at judicial arbitration and mediation, because of the judicial experience of most of their panelists. These former judges, accustomed to courtroom battles, are typically masterful at orchestrating and deciding arbitrations. Once you determine which company will be your provider, there's an important step to take before you open the door to arbitration. You must pick the correct arbitrator at the company you've chosen. Most providers have a lengthy panel of arbitrators from whom to select. It is in the best interest of all parties to hire an arbitrator with a high degree of authority, competence, and experience. All parties to the dispute should strive to work together on arbitrator selection. It is in the best interest of everyone to hire an arbitrator with a high degree of authority and competence, and a generous helping of expertise in the subject of your dispute. Even if you don't have cooperation from your adversary, your efforts alone can ensure selecting the right arbitrator. When you access the panelists of your arbitration provider, search individuals with the qualifications that fit your dispute. Most folks these days make important choices like this by reading reviews. The large arbitration providers have lengthy profiles for their arbitrators, but not reviews. Take the biographical information for the arbitrator you are considering and search for reviews for that person via Google or Yelp, or whichever review database you use. Read them all until you get a good feeling that this person is right to be the decision maker for your dispute. If they are a retired judge, you probably will not be able to locate reviews because they are not in private practice. Smart cookie tip. You'll have to decide if having reviews for your arbitrator is more important than having a former judge. Go back to the arbitration provider after you have done your due diligence and ask if they can perform an in-depth search on the arbitrator of your choice as to the number of cases they have arbitrated and a summary of their experience with the topic of your dispute. Because most arbitrators are practicing attorneys or retired judges, you want to know this arbitrator has successfully handled cases like yours. Sometimes parties have agreed upon an arbitration provider, but they cannot agree on which arbitrator to use. Share your research with your opponent. It is in your and their best interest to find the best arbitrator to decide your claim. Your mission is aligned here. If you just can't agree, ask the impartial administrator at the arbitration agency to make a choice for you. The result of the arbitration depends largely upon the competence and expertise of your arbitrator. If the above steps are taken, you will find a skilled and highly competent arbitrator, and your arbitration will be on the road to success. Key 2: Controlling discovery. Discovery is a set of legal procedures to discover facts about the dispute. Your second key to arbitration success is to take control of discovery. We covered this in the arbitration chapter. It's so important that we are going deeper with it here. You chose arbitration because it was inexpensive and fast. Discovery is the biggest gobbler of time and money. So, what is this thing we call discovery? It's a set of legal procedures, aka the litigation arsenal appropriately stationed at the entryway to the House of Horrors, to discover facts about the dispute. The most popular are oral depositions, written questions called interrogatories, and demands for document production, inspection. These processes are referred to as discovery procedures, but they could just as well be called expensive fishing expeditions. Taking depositions is the favorite of these methods. A deposition is an oral question-answer process whereby one party is questioned by another. Either you, if self-represented, or your attorney ask the questions. This testimony is given under oath and is recorded by a court reporter, to be later used by the opposing attorney against the party deposed. Costs of discovery. The cost of these procedures is inordinate, especially depositions. Often the deposition of one person takes an entire day. Your attorney's time, including preparation, is close to $4,000 alone. You've spent a day of your own valuable time either being questioned or observing the process as an interested party. The court reporter's services cost close to $1,000 a day. A one-day deposition can cost one party $5,000, $25,000 for 5 parties. Cross the top items off your bucket list, just like that. We, the people who are the victims of these fishing expeditions, refer to them as the litigation arsenal. The foundation of arbitration is economic and speedy resolution of legal disputes. Spending this kind of money on a dispute is just not the way of arbitration, where discovery is discouraged. Discovery can also be utilized in arbitration, but its use is significantly limited. If discovery is not controlled, the goals of your arbitration are not met. Discovery tools available to you. If your case is valuable and you feel it is important to discover facts before the arbitration hearing, there are several ways other than deposition to accomplish your mission. Written questions, called interrogatories, can be sent to your opponent to be responded to in writing under penalty of perjury. Documents can be obtained from your opponent by making a written demand specifying which documents you want to review. Some attorneys proceed into arbitration as they would in court, with a full litigation arsenal of discovery techniques to launch at the opponent. If you're being represented, it's up to you to tell your attorney, early on, that this is not your intent. Your intent is to save time and money while obtaining the fairest result possible, which means that discovery should be limited. Your arbitration provision defines discovery. The use of discovery depends on the wording of your arbitration provision. If it states no discovery, there is none. It can limit discovery and define those limits. Some provisions reference state statutes that specifically describe the use of discovery in arbitration. Some agreements are silent on the subject, which means that the parties need to agree to a discovery plan, which is often challenging when parties are there because they cannot agree. Depositions can be taken, if absolutely necessary, and should be limited to a certain time frame, such as 3 or 4 hours, with the agreement of your opponent. It is in all parties' interests to save money. In many cases, depositions just aren't necessary. The expense outweighs their benefit. Limiting discovery. Review your arbitration agreement to see if it defines discovery rights. For example, in California, if an agreement says the parties have the right to discovery in accordance with California Code of Civil Procedure 1283.05, that section defines the scope of their discovery. In other states, there are similar provisions which you must abide by if specified in your arbitration provision. If specified, make sure you review your state's arbitration discovery provisions to determine their scope. The California rule states that you can conduct any discovery you could have conducted in the court system except depositions can be taken only with the permission of the arbitrator. Remember, however, you and your adversary can also limit the application of these rules. It's your arbitration. Smart cookie tip. If your agreement does not address discovery rights, review the discovery rules of your arbitration provider. Their rules are typically online. If their discovery rule is too broad, limit it with an options addendum to ADR agreement. If you are represented, go through the options addendum to ADR agreement with your attorney and make good choices together. Make her your partner in keeping costs down and streamlining your case. If you don't have an attorney, go through the options with a paralegal or someone more familiar with these choices. Consult with a paralegal or lawyer online, talk to the self-help center at your court, do online research. You and your adversary are the big boss at arbitration. You can also have an initial meeting with your arbitrator to discuss ground rules and address this subject at that time. Remember, it's your dispute and your arbitration. You and your adversary are the decision makers when it comes to arbitration proceeding choices. Now is the time to adopt an agreement defining the discovery you want in your arbitration. Make the rules of your arbitration manageable and affordable. Limiting hearing duration. You can also limit the duration of the arbitration hearing in advance. Arbitration, just like any other adversarial proceeding, can take on a life of its own and run up the expense you so carefully tried to control. When you limit the hearing duration in advance, you have a stopwatch in place. The arbitrator should divide the time up into how many parties there are. Attorneys at arbitration. Arbitration is vastly different from mediation. Consider representation by counsel to protect your interests. Since arbitration is an adversarial process in which some of the formalities of court trials are adhered to, you should consider representation by counsel if you have a lot at stake and if you have an attorney fee provision in your agreement. Remember, arbitration is vastly different from the conciliatory process of mediation. In mediation, your mediator's role was as neutral evaluator and facilitator. As such, the mediator evaluated and balanced out the interests of you and your opponent. In arbitration, no one protects your interest or evaluates your case. All you have got is you. The arbitration process is streamlined and simplified compared to a court trial. Other than that, it's adversarial and confrontational. Due to these factors, depending on your scenario, it may be worthwhile to hire counsel to represent you. Just be sure you stay tuned in and control the process now that you know your options. Hiring an attorney for your arbitration. How to decide. Your decision to hire an attorney will be based upon several factors. How much is the case worth? Is there a provision to recover your attorney fees in the underlying contract? What are your chances of winning? How confident do you feel representing yourself? Hopefully you discovered these answers by using Lawsuit Analyzer. If you decide to hire counsel, the Hiring an Attorney chapter covers the attorney hiring process in detail. If the dispute amount does not justify hiring attorneys, move ahead without counsel. If there is no right to recover your attorney fees and you decide to represent yourself, you may want to enter into a self-representation agreement with your opponent that neither of you will be represented by counsel. At least you and your opponent will be on even ground without attorneys. If your opponent goes back on her agreement and shows up at the arbitration with counsel, you will demand that the attorney be excluded from the proceedings. If the amount in dispute does not justify hiring attorneys, it is wise for all disputing parties to move ahead without counsel or try again to settle. Smart cookie tip. Of course, you can contribute to your favorite attorney's bucket list fund. But do you really need to do that now that you have these tools at your fingertips? Perhaps an attorney helping hand is enough. If you have decided to represent yourself, an attorney consultation is highly recommended. You can bet your opponent has done the same thing. Go through the lawsuit analyzer in your consultation. For their hourly rate, many attorneys will sit down with clients who are pursuing small claims, mediation or arbitration and step through the facts, law, strong points, and weak points. You can have them also prepare a small claims, mediation or arbitration statement for you to use as a guide. Having this document in hand, prepared with the help of counsel, can give you the knowledge and confidence to represent yourself capably. The arbitration process. The arbitration process begins with submission of a demand for arbitration on the arbitration provider's form. The link provided here is to the American Arbitration Association, AAA, form. The rest of the providers have similar forms. This is the intake form that initiates your dispute. In advance of the hearing, each party then submits an arbitration statement outlining the dispute history, its status, and each party's legal position. The hearing proceeds as follows. Each party is invited to summarize or supplement the information they presented in their arbitration statement. Often, to save time and money, parties forego this opportunity, standing on their written summary. Then, the complainant puts on its witnesses and each party is given an opportunity to cross-examine. Documentary evidence is then submitted. Each respondent then puts on its witnesses and each party is given an opportunity to cross-examine. Documentary evidence is then submitted. Each party then gives a closing summation. The arbitrator advises that the matter is taken under submission and a decision will be mailed to the parties. The decision is generally received within a month. Differences from a court trial. Arbitration is a relaxed arena. The arbitration environment differs significantly from trial in the House of Horrors. Court is all about intimidation, which was aptly depicted in the ADR chapter. The trial judge sits clothed in a robe behind an elevated bench to preside over the hearing with a mallet. In case banging the mallet is not strong enough, a bailiff stands ready with gun in holster. The attorneys and their clients sit at tables at ground level while the jurors who are there to avoid imprisonment peer down on them from elevated seating. The court reporter takes down every word spoken at a very high price. This is the nerve-wracking experience disputing parties face in the House of Horrors. Arbitration is an entirely different atmosphere catering to neutrality and informality. At in-person arbitration, everyone sits around a conference room table where coffee and refreshments are served. In online arbitration, the parties share an online portal from wherever they are. Arbitration takes far less time as complicated evidence and procedural rules are discarded. Since there is no jury to perform for, points are driven home with far less repetition. There is no bailiff to remind you that you might be jailed at any moment nor a court reporter to take down every word spoken. Arbitration is soon and takes little time. Arbitration is heard shortly after the dispute is submitted, when memories are fresh, and issues can easily be framed. In the court trial, the incident usually happened years before. The facts have become convoluted with the passage of time. Unfolding mounds of discovery make the issues even more complex. Due to these differences, the arbitration hearing typically takes only a smidgen of the time a jury or court trial takes. Discovery is limited. The other more notable difference is your journey along the road to arbitration. The court system is a forum where expensive paper wars take place. Depositions, motions, and other costly adversarial techniques are hurled by the parties from the litigation arsenal. When you finally get to trial, you've spent years battling your opponent in the House of Horrors. You are frustrated and at wit's end. When you convene your arbitration hearing, it's early in your dispute. You've taken very few preliminary steps, and you're in a forward-moving rhythm toward resolution. Arbitration, then, is streamlined in every sense of the word. From beginning to end, arbitration is a swift, consistent process. The litigation frenzy in the court system is an emotional experience. From beginning to end, it is fraught with emotion. If you're the plaintiff, your case usually begins with a hefty deposit to your attorney or giving them a sizable percentage of your win. If you are the defendant, it starts when a process server intrudes upon your privacy. Then comes your hefty attorney deposit. With each deposit, the ego climbs on board to try to recoup your loss. Over several years, you relive the experience that brought you here through emotional surges along the way. Depositions, interrogatories, document productions, endless questions and answers. Then comes the dramatic trial, with one emotional day after the next. Finally, you experience the crescendo when the judge or jury renders the verdict. In one quick moment, the drama you have been living for years is decided. It's hard to make sense of it all. Does it even make sense? Arbitration does not create an emotional roller coaster like the House of Horrors. When arbitration participants adhere to its philosophy of minimal time and expense, it is a swift, consistent process from beginning to end, directed by the arbitrator, the master of ceremonies. A less adversarial tone. If you're the complaining party, you file a submission form such as that detailed above with the arbitration firm you and your foe have selected. It is not a lengthy complaint, using legal terminology that will be legally and factually tested by your opponent, as is required in the court system. It's a simple factual statement. As the responding party, you receive a notice in the mail that an arbitration proceeding is pending, advising you of the responsive procedures. It's not adversarial in tone, it's more like a business arrangement. In the court system, the parties are designated as John Doe versus Jane Doe. The process is confrontational in every sense. In arbitration, the designations are John Doe and Jane Doe. This designation carries with it a more professional, far less adversarial air. It indicates a matter involving people or businesses, without designating one against the other. A direct route to your judgment. After you transmit your arbitration demand to your provider, an arbitrator is selected, hopefully with your input. Shortly afterwards, you're at the arbitration hearing presenting your case. The process is swift and to the point. When arbitration participants adhere to its philosophy of minimal time and expense and customize their ADR agreement according to their needs, it is truly a forward-moving process. Unlike the court system, there are few discovery proceedings and legal maneuvers. It's a direct route from your dispute to its termination. We modern folks don't have time or interest to wrestle with our disputes for years. Arbitration is clearly dispute resolution's cutting edge. Receiving the result in private. Arbitration also concludes in a more professional, less emotional manner. Instead of being hit with the winner-loser report on the spot, in open court, you receive the arbitrator's decision in the mail. This gives you the comfort of receiving important news in the privacy of your home, instead of the tense litigation environment. For all these reasons, arbitration is a more mature way of dealing with our legal differences. You can't appeal the arbitrator's decision. Generally, there is no appeal from an arbitration award. The decision of the arbitrator is final and becomes a non-appealable judgment against the losing party. There are a few situations where appeal is allowed if collusion is present, but these are extremely limited situations. Thus, the award of the arbitrator is considered final in every sense of the word. Why is arbitration's non-appealability feature a good thing? In the court system, you finally get to trial after years of backlog. only to find that the losing party files an appeal, often just a ploy to drag out the inevitable. Then you've got another year or more to battle it out in the appellate courts, using up the money, time, and emotional investment that comes with it, before you can be deemed the victor. After 5 or more years warring over one dispute, you certainly don't feel like a winner. And your bank account is no longer your nest egg. In arbitration, when the arbitrator makes a ruling, you're done. You've presented your case, you've had your best shot. You have no choice. It's over. Now it's time to move on with the rest of your life. In the long and short run, it's a much better choice than a lengthy, costly appeal. You can create the rules for your arbitration. Court rules are set in stone, mandated by law. Arbitration is more of a do-it-yourself process where you can set up the rules and procedures in advance as you customize your ADR agreement. In the arbitration chapter, we described many ways to draft or supplement your arbitration agreement. This agreement can tailor the whole arbitration process if it is agreed to by all parties and is consistent with the arbitration provider's rules. There are many other stipulations that can be included in your ADR agreement. Our forms package includes the following stipulations. Options addendum to ADR agreement, customizing an existing agreement. Mediation, parties agree to mediate. Arbitration, parties agree to arbitrate. Mediation arbitration, parties agree to mediate, and if unsuccessful, to arbitrate. Multi-step ADR, parties agree to blind bidding, followed by mediation, and if unsuccessful, small claims if within that jurisdiction, if not arbitration. Which system does better? At times, arbitration has less than perfect results. It suffers with the same impossible mission statement as the court system, to achieve justice. But when comparing the two servers of justice, here's the bottom line. Would you rather get justice in a brief time with minimal expense, or travel a barbaric maze for many years? The answer is obvious. Do it swiftly and economically, before an arbitrator of your choice, and get it over with. How about the level of justice achieved? Which system yields the best results? The majority believe arbitration does, in that it affords you an immediate platform with ample time to present your case to an arbitrator with expertise in your dispute and with a focus that cannot be had in the backlogged house of horrors and its attendant litigation frenzy. So long as you've followed the steps recommended, you have done the best job you can and received the best result. On those few occasions when you feel you haven't received your best outcome, you've only spent a few months at most getting there. Arbitration is the choice of forward-thinking people who just don't have years to surrender to a legal dispute in an outdated, fragmented forum.